I want to say two things: that democracy and justice are not for sale in this country. And I call upon citizens to refuse any efforts of whoever it is in this country that is trying to commercialize democracy and justice. Because you would see a situation where Bobi Wine's legal team was faced with 4 respondents instead of 3 that they took to court, and an arbiter, an independent arbiter, which was supposed to be the panel of the 9 judges. As an observer of the court process, I did not see an opportunity for Honorable Chagulanyi to be heard. I did not also see fairness, given the circumstances that the petitioner had faced in terms of preparing for his petition. So yesterday, the petitioner did announce that he has instructed his lawyers to withdraw the petition. The Supreme Court regulations for presidential election petitions have regulations for withdrawing election petitions, and they demand an application which is heard and then determined. And the court did respond that they must file that application by tomorrow. I do not even know why the judiciary was responding to media statements. Because the petitioner, who is a politician and a political party leader and an MP in this country, made a political announcement withdrawing the case. I do not know why the judiciary found it necessary to respond to that political statement made in the media. Ordinarily, courts are supposed to wait and respond to matters before them. The same incident happened when the Chief Justice responded attacking the petitioner over statements made in the media about Plan B, and the Chief Justice looked like a regime activist in those statements during an open court hearing. So for court to block evidence, court to refuse a petitioner to amend their petition, court to put unreasonable timelines on the petitioner, and also to start responding to media statements is unbecoming, is unfortunate, and I think the judiciary needs to check their behavior so that they do not become a tool of abuse to the already oppressed population, a tool of abuse where citizens' only hope is in the judiciary amidst state harassment. So the judiciary should not add themselves to the state institutions that are harassing citizens of this country. I did see on Sunday the NRM lawyers threatening Bobi Wine about costs. An event that I thought was very unfortunate, because we cannot tag money to the expense of dispensing justice. Justice is valueless. You cannot value justice. So when somebody is seeking justice, you don't go throwing money. We know that the NRM is a money-minded party, and all the people maybe there are working there because of the money bags in the party. And we also know that thanks to the NRM, we have high commercialization of politics. We have also high commercialization of all other services, including endemic corruption and bribery. And we are in a pay-as-you-go kind of society. But they should not throw money and front money as if money is more valuable than justice. That was very unfortunate. But away from that, the Advocates Act provides for costs of advocates. So if court decides, and costs are awarded by court. So if court decides that indeed Honorable Chagulanyi should be made to pay costs of the respondents, I hope that excludes the Electoral Commission and the Attorney General, whose bills are paid by a taxpayer, and Bobi Wine is one of the taxpayers, including his supporters and the 3.5 million who voted for him are taxpayers in this country. So in this case, we will be looking at costs of the NRM candidate. We know they are money-minded, but I hope they will present a bill that is not outside what is provided for in the Advocates Act. So Bob Wine has been explaining, right from the time he was denied to consult, consultations are provided for in the Presidential Elections Act, under Section 3 of the Act, that a candidate wishing to contest can consult the people. There is even no timeline. So it means that if today I want to contest in 2026, I am allowed to inform an electoral commission, which is a permanent institution in this country, that I intend to contest in 2026 elections, and I should be allowed and guided to consult. He was denied that opportunity. He was arrested right on nomination as a presidential candidate. He has been arrested, I think, on 3 instances since nomination. We have seen the level of violence surrounding his campaigns. A lot of his campaign rallies have been blocked by state agencies and actors. He was illegally put under house siege by the state agencies in this country. So, I mean, those are grounds already for petition. And they don't need proof. We have all witnessed them. So there were other malpractices that we have observed as civil society observers in this election. We saw a failure of the biometric voter verification machines in so many stations. We saw violence, we saw killings, we witnessed arrest of agents, especially in the presidential election agents. So these are malpractices. We saw 308 polling stations where Electoral Commission claimed that there was 100% voter turnout. We saw another 38 polling stations in Mkono and Wakiso alone, where Electoral Commission claimed that Katumba won 100% on those, you know, I mean, really, a lot of crazy things happened. So what the court has denied Ugandans is an opportunity to know the truth of what happened in this election, and maybe that was their intention right from the beginning, looking at the way they frustrated the petitioner.